Hello and welcome back to Legal Briefs. This is the Smackdown edition where we cover all things related to the Ripple versus SEC case.
wow!
Wait a second, that was the Oscars. We're not talking about the Oscars today.
Yes, but you're talking about the order on reconsideration today.
Oh, well, let me take a look at that then. Oh, okay, well, in this case, that clip was completely accurate. Actually, let's go ahead and play the order from the judge's point of view.
Oh, wow!
Welcome back. Did you think I had left you because I hadn't done a video in a while? No, I give you my word. I'm sticking to the Ripple case till the end. I was just a little busy celebrating my 50th birthday, as you can see. And boy, did we get something to celebrate in the Ripple versus SEC case, as Judge Netburn stuck by her decision on the deliberative process privilege, and we will go over that and the big question, when and if the SEC will have to hand over those 68 emails related to William Hinman's speech about digital assets and what that might mean. Now, as you probably know, I've conjectured that there is something in these emails which is really bad for the SEC, and I'm not alone in this thought, as attorney John Deaton and a lot of other attorneys who have been paying close attention to this case have come to the same conclusion. And the SEC has certainly been acting like it with its latest extraordinary motion asking Judge Netburn to reconsider her ruling that the emails must be turned over. Now, the order has some very interesting things going on, so let's take a look at it. And first off, I'd like to look at how the judge frames the issue. Why did the defendants seek these emails and drafts of the Hinman speech to begin with? Here's what the judge says on that at the bottom of page 1. Quote, as relevant here, defendants sought certain documents from the SEC to challenge the SEC's allegations that Larson and Garlinghouse were objectively reckless in believing that XRP was not a security, and that Ripple was on fair notice that XRP was a security, close quote. Now keep in mind that the judge, unlike us, has actually seen many of the emails and drafts of the speech, and having seen them, she frames the documents as relevant to whether Ripple was on fair notice that XRP was a security. Now if I'm Ripple, I like the way she frames that issue. Now here's where the order gets very interesting. As we discussed in a video about a month ago, the SEC, I thought, made a big mistake because it had been arguing that Hinman's speech was his personal opinion, and then, for some unknown reason, in this motion, it changed that position. Now here's what I said about making that change back about a month ago. Show that Director Hinman and other SEC staff used the speech to provide public guidance as to how CorpFin, Corporation Finance Division, would apply the federal securities laws to offers and sales of digital assets, including Ether. Indeed, SEC regulations provide that Director Hinman's public statements could be relied upon as representing the view of CorpFin, the division he led, close quote. Yes, the entire argument completely backtracks on what the SEC has been saying about this speech for almost like the last year. Now in this motion for reconsideration, it has given her more very similar documents to review and changed its position on the speech 180 degrees. Now is that going to change the judge's mind on whether the emails are discoverable? I don't think so. I mean, it's possible, but I don't think so because she's already made a determination based on Hinman's affidavit. Just because a lawyer says that Hinman's affidavit is not correct doesn't make it so. It's meaningless. Nothing a lawyer ever says is evidence. Yes, there I was, only 49 years old, just a baby, trying to understand why the SEC changed its argument and wondering why the SEC set itself up for a slam down by Judge Netburn in the next part of her order, which did not disappoint. I guess that Hulk Hogan slam was more shocking. But here comes Judge Netburn and pulls a pile drive on the SEC on page 5. Quote, the SEC's assertion that the speech was intended to communicate the corporation finance's approach to regulating digital asset offerings is inconsistent with the SEC's and Hinman's previous position that the speech was intended to and did reflect his personal views, close quote. She then goes on to string cite instances in which not only Hinman himself referred to the speech as his personal opinion, but also instances where the SEC lawyer himself had made that argument. And she finishes with the coup de grace at the top of page 6. Quote, the SEC may not now argue otherwise because it disagrees with the court's conclusion. Close quote. Ouch. In 6-year-old speak, no takesy-backsies. No takesy-backsies, SEC. But look at an unintended consequence of what the SEC has done in changing its argument midstream. One thing you would think you want to portray to the court, which is ruling on a fair notice defense, is that your agency is consistent and steady in its guidance. Instead, what the judge sees in this motion for reconsideration leads to this statement from her at the top of page 7. Quote, the SEC seeks now to minimize the fact that it has publicly disclaimed responsibility for the speech. Close quote. I mean, if the SEC can't even get it straight whether the speech was his personal opinion or perhaps the entire division's guidance, and they can't even get it straight in a legal pleading with lots of forethought put into it, how the heck was Ripple supposed to know? That's the argument. Now, I just think the whole thing was a big mistake by the SEC, and of course it led to this in the order. Quote, the SEC's motion for reconsideration is denied and its motion for clarification is granted. Close quote. Now, okay, I'm sure you understand the denied part, but what was the clarification thing all about? It's right in the order at the end, and here's what she says to clarify her order. Quote, however, to the extent that there exists communications between staff discussing the speech in the context of how it implicates other separate agency deliberations, not deliberations about the content of the speech, the SEC may seek leave to redact those communications from its production, close quote. Now first, why would the judge clarify her order? Well, the SEC basically told her that it was going to appeal her ruling. Another mistake, I think, but not a topic I'm going to get into right now. And so knowing that, this is simple. The judge is fixing any little problems in her original order because she now knows that someone else will be looking over her work and making sure it's correct. So the clarification is meant to bulletproof her order from an appeal, kind of like making it a Superman order. But there is one thing in the clarification that makes me nervous, and that stems from the fact that we don't know exactly what the bad stuff in these emails is or are. Now, if, for example, the bad stuff is in an email in which someone says, well, based on your speech, Mr. Hinman, XRP wouldn't be a security, and we are probably going to be suing Ripple, so why don't you change that part so that XRP doesn't fit under your exclusion? That's me typing an email. Now, if that's the part the SEC doesn't want Ripple to see because it kills their case, that is also something, in theory, the judge's order would allow the SEC to redact. So, how will we know if the SEC is going to try and redact the really bad stuff for them? Well, that's simple. If the SEC tries further to hide these documents by filing an additional appeal, then I think it's fair to say that the clarification part of the order does not cover the bad stuff and the SEC is in trouble. Now, if the SEC doesn't appeal this order, well then I think that they think they can hide whatever is bad for them under this order of clarification. Makes sense? I mean, why appeal it if you're going to be able to hide it, right? So, what happens from here? Now, the SEC has 14 days to file an objection of the order up to Judge Torres, and then Ripple will have 14 days to respond to that objection. So, look out for an SEC appeal on or before April 26, which is 14 days. Now, based on what we just discussed, you have to change your thinking because an appeal is actually a good thing in this scenario, not only because the order doesn't hide the bad stuff, but also because Judge Netburn has crafted a pretty tight order here. Judge Torres is not going to overturn it, and Judge Netburn actually put in enough factual evidence that the Second Circuit is very unlikely to overturn it as well. And so, with this order, as Attorney Deaton said, quote, the SEC is now officially in the hurt locker. Hurt locker. And also, I will leave you with this from my Twitter friend, Attorney Bill, the lawyer from down under. Sounds like a male review show. And here's what Bill thinks in a very logical and well thought out tweet thread. This is what he says, quote, now is a sweet spot for settlement for several reasons. I base my thinking on my experience as a litigation lawyer and nationally accredited mediator and in my involvement in hundreds of settlements in a different jurisdiction, but I hope the reasoning is sound. After the evidence of both parties has been largely gathered and reviewed by the lawyers, is a prime time to hold serious settlement talks. We are at that point. And then there are the 68 emails and drafts. The SEC is in a mess on this battle, but it still has leverage. Why? Because it can appeal, it can delay, and because Ripple doesn't know what is in the documents or whether they will ultimately obtain them. The SEC does not need to apply on this issue to Judge Torres to gain more leverage. Right now is a good time, not necessarily the best time, to have settlement discussions before it needs to apply to Judge Torres. At the same time, the risk that the SEC will have to hand over the 68 emails and drafts has just dramatically increased with Judge Nipburn's latest decision and SEC's almost hopeless appeal prospects. Ripple has been very quiet the last few days and not commented on the latest decision. I wonder why. I am entertaining the thought that serious settlement talks are already underway. Close quote. That's from my friend Lawyer Bill on Twitter. Give him a follow. He said it, not me. Thanks for watching. That was so short, it must be getting old. By the time I'm 60, it's going to be about 30 seconds long.